This is wonderful. I'm going to go ahead and share my screen, and you can see everything?
Yes, Andrea, would you mind introducing yourself briefly?
Okay, great, sure. I just want to make sure that you're seeing the correct screen because I have two different screens set up. So the screen that you're seeing is the full screen. It's not the performer or the view with the slides.
Yes, I see a lot of Mona Lisas.
Perfect. That's exactly what you should be seeing.
Okay.
So hello, I'm Andrea Wallace. I'm a lecturer in law at the University of Exeter. And my research looks into how institutions make works in the public domain that they hold in their collections available. Also, what types of works should be made available online, and how institutions go about doing that. So I thought I would approach this by addressing kind of the various issues that arise during the management of heritage and extending access online. So should I just continue, or do you want to do introductions of everyone?
Briefly, I might just briefly introduce everyone.
Okay, perfect. All right, go ahead then.
Okay, so hello everyone, and welcome to our 9th and last session for this year of the Sunoikisis Digital Classics on Cultural Heritage module. And today we're talking about copyright and open access for cultural heritage. Our speakers today are Andrea, that just introduced herself, but then we will also have Emma Payne from King's College and Gabriel Bodard, that you have met a few times before. And because we have a lot of things to talk about today, I'm just gonna give the spotlight again back to Andrea, and then the speakers will know what to do next. So Andrea, it's back to you.
Okay, perfect. So I thought I would approach this by, again, just kind of talking about the issues that could arise during the management of heritage and extending access online. So instead of, like a more comprehensive introduction, because honestly, this could fill an entire course of its own, I thought I would kind of use this to approach this from an issue spotting perspective. So I kind of wanted to flag some of the potential issues that might arise during each stage of the process, but this is, by no means exhaustive. So initially during the pre-digital stage, where the focus is on the material object, there's an entire amount of work that goes into making it ready to be ready to digitize. So part of that includes the internal rights and audit assessment, assessing whether there may be any donor restrictions or whether the underlying work itself is in copyright or in the public domain. Sometimes that question leads to the result that it's an orphan work and we don't know who the copyright holder, the rights holder of the work is, and how to seek them out for permission. But there can be other permissions that apply, specifically because sometimes the material might be sensitive. So, then the question arises of whether access is even appropriate, or whether we might, seek out cultural permissions in order to extend access and digitize it. And then there's some risk that's perceived. So risk in digitizing alone, but also the risk in making it available. And again, because the law is involved, this can become very jurisdiction specific. So for example, there might be additional considerations like in Italy, where by law, you might be required to pay a specific fee in order to use a public domain work. So this is called the domain public payant. And there's other jurisdictions that have similar restrictions as well. But then assuming that now we're ready to go into kind of the digital phase and making the digital surrogate, there's this other question, and this is where I'm really, really interested in whether there's any rights in the new asset. So within the law, we ask the question of whether it's sufficiently original to attract a new copyright, or if there's other components in the process that could attract IP protection. So maybe specific data or database protection, or even the workflow product and how that's designed. And then there could be additional rights that are claimed that aren't related to copyright. So terms and conditions and how people are able to access stuff online. Also, copyright policies online can overreach what's normally legally allowed. So they can kind of like creep into what would be allowed via fair dealing or fair use. And then we have jurisdiction specific issues because, and I love this, it's, everyone who's trying to pay attention to what's going on within a jurisdiction, users on the internet are obviously thinking about that. There's a little bit of, some tongue in cheek there, but But then again, we start to think about the post-digital status of all of this content. So what happens when it's made available online? Are users potentially exposed to the risk of secondary infringement by downloading and reused content? Or will the context, the educational context, be lost? Some ways of trying to navigate these issues, institutions might apply Creative Commons licenses. And of course, Creative Commons licenses are appropriate when the underlying content is in copyright. But if it's not in fact original, then a Creative Commons license might be inappropriate. And then we have the tension with Wikimedia Commons. So a lot of third-party platforms might require the type of content that you make available online to be available for non-commercial, for all use. So a non-commercial restriction could prevent those communities from using the content that's made available online. And then, of course, because we're creating new media, we have a lot of legacy issues. So there's new technologies that are required to make these assets, but also technology changes, so we have metadata formats that change. Also, institutions might have to collect the hardware in order to access all of this content later. So, not to overwhelm you with the potential issues that could arise, but all of these kind of feed into some of the really interesting treatments that we might see online that I'm going to talk about as motivations for why to restrict access. So building on that, I've kind of divided the presentation into these 4 themes. And I thought first we would kind of tease out some of the issues in gaining or extending access to digital surrogates, and then compare this with corresponding restrictions about access to the material object, should the visitor want to make their own reproduction, and then show how entrenched the desire to commercialize content is when it's translated into the online environment through terms and conditions, but also explore how all of these various restrictions are being challenged by users and visitors via the technology that's made their commercialization possible to begin with. So in accessing the digital surrogate, again, copyright varies by jurisdiction, but it generally automatically attaches the moment that an original idea is expressed in a material form. So the threshold for what is quote unquote original varies by jurisdiction. So in the EU, it has to be the author's own intellectual creation. But copyright then lasts during the artist's lifetime and upon their death for 70 more years, and the heirs will enjoy the copyright. It then passes into the public domain, and it's available for anyone to use, to reproduce, to put online, to appropriate, and so on. So, in this instance, copyright didn't exist in 1503 when Da Vinci made the Mona Lisa, so he actually never enjoyed copyright in this work. But often, during the digitization of the work, which arguably kind of contradicts public domain law, a new copyright is claimed. So the claim is that that new work has met the threshold of originality. And because copyright automatically attaches, if that's the case, we would actually have to go to court in order to tease out whether a work is truly original and worthy of copyright. And that's not only expensive, but it would require someone to sue a user who has allegedly infringed that copyright. So that would also risk someone setting precedent that the requirements for a new copyright have not been met in digitized material. And that's a risk that anyone wants to avoid who is using digital reproductions to commercialize and generate revenue. So to put this into context, if you're thinking about this in terms of the Mona Lisa, we have the image here, which once you look a little bit closer, you see is Aramin, Grand Palais, Michel Hurtado copyright. I like to think of this in terms of, okay, if this is a new work, it's a new work titled X200, this is, the title of the file. And according to the metadata that was embedded in this work, it was created in 2014, which means this image will ascend into the public domain in 2090 when no one's going to be using low resolution images in their work. So there's kind of this perpetual issue that continues to exist. And this is what you'll see if you go to the Aramin Grand Palais website. You're going to have to contact the institution and license the work in order to use it. But this issue has a historical element to it. So, institutions today are digital and they're made with photographic technologies, but surrogates were originally made by hand. And at the height of reproductive printmaking in the late 19th century, engravings were kind of seen as one of two things. So either as an interpretive engraving, that was a new work in and of itself, or a facsimile engraving, which took an incredible amount of time and skill to produce, but it wasn't viewed as a creative product for a number of reasons. So, of course, these surrogates, if we're thinking about it in terms of, oh, they're all prints, they're now in the public domain. Again, that's just not the case because each ends up being restricted by a copyright claim. And as we see technologies progress, so from painting to printmaking to photography, it has the effect of locking up the public domain in perpetuity as each new reproduction made by a new technology has a claim to copyright. So again, these are all actually surrogates of surrogates. They're digital files of the original work, except for the digital photograph on the very, very right. And each one may have had copyright when it was made, but now because the copyright is claimed, the access is restricted, and it has this effect. So these two images are public domain courtesy of the Getty and also the Library of Congress. For the most part, reuse is dependent on whether the steward has dedicated the digital surrogate to the public domain. So interestingly, when we look at how institutions treat surrogates differently when the material object is in copyright versus when it's in the public domain, you can look at this Tate image that is marked copyright David Hockney because it's a copyright of his a copy of his in copyright work. But then this Malay painting, who died more than a century ago, so the material object is in the public domain, is marked copyright Tate and released under a CC BY NC-ND license. So even though the underlying work is in the public domain, the same process in this instant has created the new original work, which, as we can see in comparing, becomes kind of problematic. But for argument's sake, let's say that the copyright is valid because there are some jurisdictions where maybe there would be a different outcome. Maybe that threshold would be met because they have a lower standard for originality. So then what's fair for everyone should be fair for everyone. If cultural institutions could make a reproduction and commercialize it, so should everyone else. But we know that that only extends potentially to people who are able to visit Paris and go to the Louvre and pay the €11 fee and make their own reproduction to use and commercialize publicly. Except in reality, as you enter the building, you're bound by the Louvre's visiting rules, which restrict use of photography taken inside the museum space strictly to private use of those photos once outside the museum space. So the combination of these restrictions really creates a monopoly around our common cultural heritage in the public domain. And it conflates rights and property with rights and intellectual property, as well as ownership with authorship. But this is, pretty typical among cultural institutions. These are some kind of examples of institutions in the UK where we have visitor photography policies that by and large restrict use of photos to personal use. But then there's some that do allow use for non-commercial use or study. Some of my favorite examples to stumble upon are the ones that require prior permission by the curator. So Victoria and Albert, of course, has as agreed in advance by the curator. But this kind of amounts to a third-party restriction on the visitor's enjoyment of a copyright in their own work, because in effect, by contract, by entering the institution, the cultural institution's imposing different rights on the content that's created within the walls. But we also have the question of whether this matters because it's almost impossible to enforce. We have visitors who are coming equipped with increasingly sophisticated cameras in their phones. And there's a proliferation of images throughout Instagram, Twitter, Facebook of different experiences. But there's conflicting policies, even around material access as well. And I always like to show kind of the difference between what an institution might say online versus what a a visitor would be presented with at the institution. So with the Musée d'Orsay, if you do find the policy online, you'll see that it links to a specific page that has an 18-page visiting rules and regulations document in French. So, it's not universally accessible. And the bottom part specifies that photography for commercial purposes must be pre-approved. But when you visit the museum, this is all you'll see. So there's a policy that prevents flash photography and selfie sticks, and the visitor will never be presented with the more restrictive policy at any point during the visit, which really raises the question as to whether it can actually be applied or enforced against the visitor. So when we're thinking about access to online content, it can get pretty crazy out there. So this is something that I explored in a recent project with Professor Ronan Deasley at Queen's University. We were taking all of this in mind and kind of wanted to explore what would happen if we did look at the institutions as the authors of the works themselves, and especially if we removed the context of the original author and artwork, if we could learn anything about the claim or the legitimacy or the exercise of intellectual property rights over the surrogates in the process. And we put together this exhibition called Display at Your Own Risk. So it's a research-led exhibition, and it features digital surrogates from different institutions around the world. And it examines the path that a public domain object takes during digitization and really challenges whether the work status and authorship norms should change because there's a new asset that's created. So we visited all these institutions' websites and downloaded recognizable works and printed them to the dimensions of the material objects. And then we hosted an exhibition of new works by cultural institutions. But we also digitized the prints and we put them into categories of risk in reuse that was kind of accompanied with information about each of the institution's rights and reuse policies. And then we made it all available online as an open source exhibition with a file that users can download, with everything organized so that they can make informed decisions when creating their own versions of the exhibitions about what level of risk they're willing to encounter with regards to the online policies and copyright concerns. But in the research leading up to the exhibition, it really became clear that there was an overwhelming lack of standardization among the sector. So there's no standardization of terminology. They can be called, anything across the board from oppressum to about this site. And what might seem obvious, using copyright as the name of the policy is actually not, because only 16 institutions out of the 130 that I reviewed used that for the name of their copyright policy. So that means when users visit web pages, they have to really sort out even what the copyright policy is called and where it is located before they can proceed to finding out what it means and how it applies to reuse. And that's even simplifying it because, for example, with the Tate, this is the copyright permissions and photography policy, which comes with dozens of conditions and caveats, which you'll see highlighted in yellow. But it's actually one of 10 policies that are located in various places online on the website that address online and on-site content. And this last one, which is titled A Brief Guide to Copyright, is actually a 65-page document. And it covers a number of issues, but it does not even mention the public domain. And then we also have a visitor photography policy, which specifies that photography is permitted in the main galleries for personal and non-commercial purposes, but it places the onus on the visitor to determine whether copyright might be infringed, even though it doesn't tell the user what that means or mention the public domain. So just to quickly show some other examples of how conflicting policies might change or mediate online engagement, we have the British Library's website for terms of use, which is in the footer. It takes you to the page, which actually has 5 sub-policies, including the copyright policy. And the policy informs the visitors of the various types of content online, but it has another policy there on the side, which is the British Library Intellectual Property Policy. It's a PDF direct download that the user will actually never encounter. It's not technically part of the website, so it raises the issue as to whether it can apply to anything online and bind the user's engagement with the content. And when you go to visit the works, you see things like this. So images with conflicting information. Here it says usage terms, public domain, but directly underneath, held by copyright, British Library. And even among the works that are marked more clearly, like this one that says public domain, when you download the file and check the metadata, there's often a copyright claim embedded in the image. So maintaining accurate metadata is, it's a huge legacy issue among the sector because things might be automatically embedded during the generation of the work that then would have to be modified, and there's just too much work to do. But from the digital surrogates that are kind of downloaded directly from the institution's websites, there were 37 that had no metadata attached to them at all. And if we think about that in terms of a new asset that's then uploaded to the internet, they become a de facto orphan work once kind of taken away from the context of the institution's website. But 65 of them contained no rights information. And then when I checked all of this against the claims that were made online about the institutions, the websites claimed that 72 out of the 100 were in copyright, but actually only 19 of those had their rights information embedded in the metadata. So again, there's a lot of conflicting practices, again, that can be restricted due to technology, actual workload capability, and what's possible. But it can have downstream effects that can limit what a user is allowed to do with the work later. So another example that's listed in the case studies that I just want to briefly touch on is Art UK, which is a website that aggregates images of all of the publicly owned works in the UK. And at first glance, it has 2 relevant policies. So there's terms of use and copyright. So if you go to the terms of use, you'll see there's a contract of adhesion that's telling users just by accessing the website, they're deemed to have accepted the terms of use and they must abide by them. But then the copyright notice is actually more of an instructional notice just about how many works may be in copyright or could be reproduced within the terms of the institution's license. So if you go to view a work directly, you'll see that alongside each image, like here, this National Gallery surrogate, it says, how can I use this image? And this jumps down to tell you that it's copyright, all rights reserved, which is interesting because the National Gallery releases higher resolution surrogates via its own website under a Creative Commons license. But clicking on more information will take you to this kind of hidden page that's called image use. And it tells you how the content might be managed. And there's 3 sub-policies, so image use, Creative Commons, and copyright. So again, thinking in terms of how this actually applies and what's made available, RUK does allow you to sort through the works that are available. So here I've done a sort to see how many images are made available through Creative Commons licenses, and it's a substantial number. But when you go and you actually sort according to how they've been released, you'll see that there's no records to display for works that are either public domain or CC0. And I did a little bit of math, and I've kind of broken down. We got CC BY, there's 275, CC BY SA, 136. And as you go down the list, the images are more and more restricted. So even though we have about 220,000 images, 25,000 of those are CC licensed, but around 400 are open CC license. And then we have the 460 that don't allow for derivatives to be used from the images. So there's other instances where, like this institution, the National Library of Wales, has a copyright policy. That's another general notice. And when you click on the intellectual property rights policy, this contains the information that tells you that the reproductions are subject to the same rights that would apply to the work in its original format. So we have these issues of whether the copyright exists to begin with, but then we also have the issues of how that information is communicated to the user. And especially there may be conflicting uses. There may be terms and conditions that claim more than what a copyright would actually allow the institution to do. But there's just no standardized practices out there. So I just want to briefly touch on kind of how disruptive potential of technology and how the growing pains that are caused by technology, especially at the pace at which it's advancing, are actually encouraging people to kind of challenge these practices to begin with. But what we're beginning to see is that users in the private sector are kind of responding faster to the direction that surrogates and openness is taking. So there's a couple of examples here, both of which make their content available that is original content online as either CC0 or under a CC BY NC, so that allows educational uses. But another example that's mentioned in the case studies is the 2 artists that visited the museum that hosted the Nefertiti and allegedly scanned the bust with a camera that was hidden beneath the scarf. And you can see in the video that they're kind of circulating and scanning the bust and release this really, really high quality data available online for download. Of course, the museum was really upset. And some of why people suspect they were upset is because they've actually scanned the bust themselves and have made a 3D printed replica that has been painted. And they sell it for almost 9,000 euro, excluding VAT, online. So a lot of people are speculating that, dependent on the technology, it's actually more likely that they somehow hacked this data and got a copy of this data rather than making it themselves in the museum space. And the museum says online that they've gone open, but here we see that open is a thumbnail-sized image that's on a white background and it has the artist information, the CC BY NC and D license, and the museum's copyright and logo, but none of it is really readable either at thumbnail size or when blown up. Like, it's very pixelated here. And the Nefertiti data has been downloaded and remixed for a number of reasons, especially retextured and released for purposes of study. So, here we have users filling the gaps that are left open by the museum. But again, 3D surrogates, if we think about it in a historical perspective, they've always been a thing as an object of study. And the V&A even has an entire gallery dedicated to the display of the high quality surrogates that they have in their collections. But today we're taking that step towards digital. And in doing so, we're starting to see instances where, for example, the Virtual World Heritage Laboratory is digitizing the Uffizi Gallery's collection. And in doing so, we'll make surrogates that are, just the raw data, will be the raw data that has kind of been restored to what it would have looked like when it was originally made. And then also print copies for loan. So copyright might apply to different layers of the data that's comprising these surrogates, but this is the direction that surrogacy is going. And this is even affecting 2D works. So another kind of thing to think about is how AI, like artificial intelligence, might be supplanting authorship. So the Mauritshuis Museum has been working with ING and Microsoft. They've developed this technology that has analyzed a dozen Rembrandt portraits, and they've generated actually a next Rembrandt. So, you know, they try to think in terms of the body of work, what the next portrait would be. And this is 3D printed. And so not only have they made the technology that's able to do this and, you know, analyze it, but now they're claiming a copyright in this work as well, which is a computer generated work. So, you know, it's really important to think about how we settle the issue at its most basic level. And I really love this article from the Washington Post that, you know, is talking about how the digital technicians literally hear the beeps and whirs of the Smithsonian conveyor belts in their dreams at night. But the absence of originality isn't just due to this type of technology. It's because, you know, throughout the industry, creative choices are being limited in a lot of different ways. So best practices, digitization guidelines, standardized method, the choice of technology may be restricted. There may be a lack of choice in subject matter and representation, and the list goes on. But it doesn't necessarily mean that an institution can't charge for images. It just means that we need to be approaching this from kind of a service fee perspective for providing the image rather than a copyright fee, which is a lot bigger and looks completely differently. And then the bigger issue then becomes kind of this sense of hypocrisy on behalf of the stewards who are using the public domain to commercialize the cost of future knowledge generation. So the Tate has actually received kind of some criticism for this recently because they've started sourcing their bibliographic information from Wikipedia. And so when you view an artist's bibliography, there's a statement disclosing that the content comes directly from Wikipedia. There's a link to the page. But for its own images, for its own content, it's licensed CC BY and C&D. And in order to use it for commercial purposes, sometimes you have to pay a substantial fee. So there's this question of trying to support the open access movement, but at the same time, doing so on your own terms that should kind of be challenged. So to conclude, it's kind of this argument of trying to think about hand processes and new technologies is not just another medium for making new works, but especially another medium for slavish copying and especially for disseminating knowledge. And accepting this argument is kind of the first step toward the attitude shift that's required to kind of implement an open philosophy. And the argument isn't new because it goes all the way back to the Renaissance. It continues in the debates and the justifications for legal protections for engravings and later for photography. And it's especially relevant today in the context of 3D digitization. So as our reproductive technologies continue to advance, we should really honor the content that's in the public domain and make sure that it remains in the public domain. Thank you.
Thank you, Andrea. I'm sure there will be a lot of questions afterwards. I'm now presenting Emma to everyone, and you can start, Emma, anytime.
Okay. Hi, so I'm Emma. I'm speaking today from my perspective as an academic and editor with experience both in journals and book publication in heritage and archaeology. I'm going to talk a little bit about the main issues we face in publishing concerning copyright. And I don't really have any answers, but hopefully this will show you what some of the issues are. And I'll try not to repeat too much of what's already been said. So I've been an editor with the Journal of Conservation and Museum Studies, or JCMS, for now over 5 years. And I worked in academic book publishing for over a year. And copyright is a really frequent stumbling block that we as editors or as authors come across. And so I'm just going to share some of my slides now. Hopefully everyone can see that.
Yes, we see that. Thank you.
Good, thank you. So a lot of the problems that we have stem from the extremely vague term fair dealing. This is not defined in law, which allows a certain flexibility that in many ways is probably a positive thing, but also causes a great deal of uncertainty. So the government's guidelines state, fair dealing is a legal term used to establish whether a use of copyright material is lawful or whether it infringes copyright. There is no statutory definition of fair dealing. It will always be a matter of fact, degree, and impression in each case. The question to be asked is, how would a fair-minded and honest person have dealt with the work? So this is not very clear. Fair dealing means that you can use material under copyright without gaining permission from the copyright holder for certain purposes. The most relevant purposes for us are the use for non-commercial research or private study and for criticism, review, and quotation. Both fair dealing, however, and the idea of the commercial are open to a certain level of interpretation, and that can make publishers very nervous. Of course, the two components that we're dealing with most of the time within publishing are text and images. Copyright can apply to both of these. If, for instance, a poem was published in the UK by an author who is living or died fewer than 70 years ago, then it will be under copyright. Normally, the copyright holder will be the author, but it might be their publisher or their estate if they've died. If you wish to use this poem then in an academic book or journal paper, do you have to seek permission? Well, no, not necessarily if the use comes under fair dealing. So I'm going to set aside the debate over commercial versus non-commercial for a second and focus on fair dealing for the purposes of criticism and review and for quotation. So this means that whatever you quote needs to be no more than is required by the specific purpose for which it is used. It must be properly acknowledged and genuinely for the purpose of quotation. In practice, therefore, if an academic author uses a short quotation as part of their argument, then this should be fine as long as it's referenced. Problems can arise, however, if quotations are used outside of the main thread of the argument and if the quotations are very long. As a result of this, publishers will often have their own guidelines. Indeed, they may have two sets, one for internal use regarding how their own editors and authors use other material, and one external set laying out how others can use the material that they publish. So Wiley, for example, says that you should always seek permission for a single quotation or several shorter quotes from a full-length book, more than 300 words in toto, and for a single quotation of more than 50 words from a newspaper, magazine, or journal. However, no numbers are actually given by law. Any limits given, such as those stated by Wiley, just reflect how they've chosen to interpret and apply guidelines surrounding fair dealing. So we can already see that the law is quite vague, and this makes publishers inclined to take a very conservative stance. In fields like heritage studies, which aren't typically well funded, this can have quite negative implications. In the vast majority of cases, authors are themselves responsible for paying any fees necessary to clear copyright permissions for either image or text. They may often simply choose not to include relevant images and quotations because they can't afford the fees and can't be certain whether or not they should be paying them. Complicating matters is the notion of fair dealing, non-commercial research or private study. So private study is fairly straightforward, but the distinction between commercial and non-commercial is less clear. The journal that I work for, the Journal of Conservation and Museum Studies, is totally free and open access. I would say, therefore, that this is genuinely non-commercial. However, the book publisher I work for would certainly be considered commercial in most senses, and that's the case for almost all book publishers. So books are sold to make a profit for the company and authors get royalties. The profits made on these academic books are, however, small. You have to publish a lot of them to be a viable business, and the royalties for authors are very, very tiny. Indeed, because the print runs are so small, these academic books were in some cases considered non-commercial. So this is a good juncture at which to start talking about images, which of course are particularly relevant for publications dealing with heritage, and which we've already seen in the previous presentation. So some of the images I obtained for books were done so at non-commercial rates, either reduced or free of charge, because the books were considered academic, scientific publications only available in a few copies. But this really depended who we were dealing with. Some organisations charged commercial rates and some were non-commercial or waived. There isn't much consistency in this respect. Some museums, for instance, will consider such books commercial, other museums will consider them non-commercial. Likewise, with big image suppliers like Getty Images and Art Resource, might or might not treat academic books differently to trade books. These inconsistencies surrounding what constitutes non-commercial publication and the difficulties in obtaining permission to reproduce images in academic articles and books have been written about by Michael Squire in his review of the book Images for Classicists, which I've put the reference for at the top here. I'd recommend taking a look at this just because it's only a few paragraphs and contrast the very strict view of the commercial taken by the British Museum with that of the V&A, which allows free use for academic publications, as you can see here. So this leads me to the final issue I would like to raise, which does overlap slightly with the previous presentation. So while we may choose to pay to use a museum's own photographs of one of its objects, what happens if an author has sourced an image from elsewhere? So we want academics to be able to include photographs of the objects they're discussing in their papers and books, but the fees for official photography by museums can be expensive, particularly when you want to include a large number of images. So for instance, perhaps they or a colleague took a photograph of an ancient sculpture while they were visiting a museum and they want to use this image. Is this okay, or do they need to ask permission to use their own image? So if we take the British Museum as an example again, looking at some more of these visitor regulations and how they contradict each other all the time, these ones state you may use your own photographs, scan data, film and audio recordings only for your own private and non-commercial purposes, which include use in personal, non-commercial social media profiles, blogs and websites, provided no further commercial reuse of the content is permitted by the terms of use of the social media platform or website. The British Museum says that they consider anything that is in itself charged for, including textbooks and academic books or journals, as commercial. So they don't include under commercial free open access journals, but they will include other journals and books. So we might ask the question over who holds the copyright in such cases. Who owns the copyright of the object? Can a publicly funded institution own the copyright of an ancient object and charge people to publish their own photographs of it? As we've seen, possession does not necessarily convey copyright. Modern works of art are likely still to be under the copyright of the artist rather than the gallery in which they are displayed, but clearly this will not be the case with ancient objects whose makers are long dead. To quote the Petrie paper which is on the reading list, the stance of many museums appears to be that even if they do not own the copyright to the works in their collections, they might at least own the copyright of the reproductions of these works. However, as we've seen, it's far from clear that this is accurate. But will publishers or authors then get into trouble if we use such photographs without seeking their permission? Perhaps. It's certainly possible that a museum may choose to bring legal action, although I imagine that they would be very unsure over whether or not they would win the case. Often as editors, we end up just trying to avoid the issue. We would encourage authors to make use of open access image collections. The Metropolitan Museum of Art now has lots of open access images, as does the Getty and the Yale Centre for British Art. Of course, sometimes you do need something really specific, and so if the fees were unaffordable, then we might commission a drawing. Of course, then is a precise archaeological drawing really much different from a plain photograph of an object? But that's perhaps a question that we could maybe return to at the end. So if I try to go back.
Thank you, Emma. I think we can now switch to the second part of this class and talk now a little bit more about open access. And it's now Gabby that will introduce us to the second topic. You need to unmute yourself.
Great. Thanks, Valeria. And thanks, Andrea and Emma there. I've actually learned a lot from your presentations there, and I may have to change some of the things I was going to say accordingly. So that's really useful. So yes, as Valeria says, I'm going to talk a little bit about open licenses now specifically, and my thesis is what the ways in which these sorts of open licenses are absolutely essential if the work we are to do in digital classics, in digital cultural heritage, is to be considered scientific work in the way that we research has been defined in the last 200 or 300 years. So if we're really to make reproducible research outcomes, we have to make some of our work available in ways that default copyright would not allow. I've got a few slides. I'll just quickly share my screen there. This is from a longer slideshow, which I've used sometimes, but I won't go through every single slide. So these slides are available online. There's a short URL at the bottom there of the screen, and I will also make some of these slides available to Valeria to upload as part of the PDF for the session. But the overall argument of this session is that, as I say, open source software, which I will define slightly, and open access publication, which is a slightly different, although analogous, model, and the open licenses that allow both of these things are an essential part of open scholarship. And I won't define open scholarship in any great detail here, although there's an article on the reading list which does at more length. But rather, I want to talk about the way in which digital scholarship, in particular, cannot be open without these open licenses that we talked about. So very briefly, to talk about open source software, this is probably something that most of you are familiar with. But the general idea, this is sometimes called free software, with the special definition that free means free as in speech, not as in beer. I.e., it's not necessarily something that you don't have to pay for, but it is something that you are not restricted in how you can use. And the open software model is a software management model, effectively, which is designed to enable and empower massive collaboration, including what I'll call asynchronous collaboration. So one example of an open software license is the GPL, the GNU public license, the general public license, which defines, as you can see in this summary of it, the rights that you would normally have in something you have created under copyright, which to a limited extent you are waiving. So you are waiving the right which normally would not allow anyone else to modify or adapt or to redistribute copies of the software or of the underlying code. This means, of course, that you have to own the software before you can open license it. There are many different open source licenses. The idea of which is that you can reuse and redistribute the software you're working with, and some then say your use must be non-commercial. Some say your use must continue to be open source if you redistribute it. But some say neither of those things. They're much more liberal than that. And in general, they would allow modification and remixing of the content. And so, as I said, you can only put something in an open source license if you have copyright ownership of it. If something is in the public domain, that is to say no copyright applies to it, then it is not open source. It is more liberal than that. It is something which can then be used with no restrictions at all, including no need to attribute the original author and so forth. It's very unlikely that software will still be useful at a point at which it goes into the public domain. If something ceases to be in copyright 70 years after the death of the author, can you really imagine software still being useful 100 years later than it was written? well, we certainly can't now because there is no software from 100 years ago, but I still find it hard to imagine that will be true even in 100 or 200 years' time. I want to argue that open access publication is in many ways analogous to open source software distribution, with the major difference that with open access publication and open access licenses, we are talking about free as in beer. The whole point of an open access publication is that you don't have to pay to read it. And there's all sorts of materials that are released in open access, and as usual, open access materials must have, in order to publish something under an open license of this kind, you must have copyright in it in the first place. Some open access publications are fully restricted under copyright, just as fully as they would be if they were published in print. Others have some rights waived. In particular, with academic publication, there is an argument that on the one hand, the production of this is generally public funded, or is in any case considered to be a public good, and that there is a very strong interest both in the culture generally and on the part of the author as well, in very wide access to this material. As Emma pointed out, authors very rarely make very much money from publication of their research anyway. So I think almost every academic author would rather receive more readers than fewer readers and more restricted readership and people having to pay for them and so forth. So open licenses will waive some of these copyright protections. Just as we said with open software licenses, this usually allows redistribution, it usually requires attribution, and it may or may not require commercial use, non-open use, and transformative use. And so we've had a lot of mentions of the Creative Commons so far. I just want to talk about that a little bit more. Creative Commons Creative Commons licenses specifically work alongside copyright, so they're not an alternative to copyright. They're a way of working with copyright and waiving some of the rights that copyright automatically gives you. What Creative Commons licenses don't do is give you any rights that you don't already have through copyright. And so the standard Creative Commons licenses, these are some of the titles and acronyms that we've seen already. The standard Creative Commons license is CC BY, Creative Commons Attribution. And this basically means people can do whatever they like with your work, but they have to attribute anything, any redistributed version of the work to you. They can derive works from it, which would include, for example, if you published a novel under a CC BY license, someone could make a play or a film out of your novel without having to ask you permission or pay you any rights, etc. It gives people complete freedom to reuse and remix your work. And then there are the three types of restriction which you can attach to a standard Creative Commons license, which are share alike, which means that you can do anything you want with this work, but when you redistribute it, it must also be under this license. If you don't have this, then someone could redistribute and remix your work and then copyright it, the new work, without putting it under an open license. There is the non-commercial license, which restriction, which, as we've already heard, is problematic in terms of what it means. And I have very seldom seen an academic work where a non-commercial license did more good than harm to the author who was trying to distribute their work. And then there's no derivative, which basically means you can make nothing but verbatim copies of this work. And this is maybe useful if you're attaching a creative license so that something gets a massive readership, but you're not interested in people reusing or remixing this work. With data of the kind of thing that I'm going to argue is very essential to put under open licenses, no derivative would be a deal breaker. And in fact, for open data that you really want to be distributed and for other people to reproduce your work and recreate your arguments, I think anything other than any restriction other than the vanilla attribution license is going to make work harder for other people to reuse at various steps. And almost none of those things will actually achieve anything that you really want them to achieve. So my argument is always, when speaking to academics who are deciding how to license, they will go with CC BY. Nothing else will actually help. It'll always make things harder. So the other part of the argument, which I won't go into in great detail here, is to talk about the concept of open scholarship. The basic concept of this is that since the Enlightenment period, we have recognized that scholarship requires freedom of speech, independence from government or church interference, and the need for rational argument. So pronouncements cannot be made by the authority of the speaker. The previous scholarship has to be cited, evidence has to be given, methods have to be reproducible. And so then we have this concept of asynchronous collaboration of the kind that I've mentioned already, where a scholar has written a book, and a generation later or a century later, another scholar writes a book on a similar topic with various references back to the original book, and creates a new book. And this is very much a collaborative work, because this work wouldn't have been possible without the earlier work in the earlier book. And there's various different ways we can express this scholarly method and this asynchronous collaboration in different disciplines. So there's the most scientific, if you like, in experimental physics, through to the most theoretical in something like literary criticism, and in classical philology, which is my discipline. We have this concept of the apparatus criticus. We have very rich bibliography. We always have historical commentary, which almost inevitably engages with previous authors. And most importantly, we publish our source data, our photographs, facsimiles, and references to comparanda, so that there is no way that we do not prevent readers and scholars from doing what we have done, and checking every single piece of our work and coming to potentially different conclusions based on that. And so scholarship, I would argue, this scholarly method is exactly the open source software method, where the source code is your photographs, your images, your plain texts, and your binaries are your written arguments in print and so forth. In digital scholarship, this is particularly important because unlike a book where my source code is my footnotes and my bibliography, effectively, which reference both to primary and secondary material behind my arguments, your source code in digital research is literally code. And so if you don't make both your data and the software that helps you to interpret that data available in some way to later generations of scholars, and later generations in digital scholarship is often next year rather than next century, then your work is not reproducible, and you are not, following the rules of the post-Enlightenment university. You're going back to the 17th century and saying, you have to believe me because I say so, because I'm an authority in this field. And so these are some of the examples of things that, if you have data based on a digital tool, other people have to be able to do with your data in order to continue working in this way. So I've raced through that. This article here is on the reading list, and goes through some of these arguments and many other things in more detail than I've been able to here. But it's that last point that I really wanted to leave us with, that we reconstruct we allow people to reconstruct our research, and we work. Therefore, we work in an academic way for doing this sort of digital work.
Thank you, Gabby. And I think that Emma has a case study to discuss for us.
Yes, so I'm just going to talk quite briefly about some 3D imaging work that I completed as part of my PhD, how this relates to questions concerning both open access and copyright, and how I might do some things differently if I was starting the project today, in light of things that Gabby's just been talking about. So my 3D project involves scanning of sections of the original Parthenon frieze displayed at the Acropolis Museum in Athens, as well as historical plaster casts of the same sections of frieze held by the British Museum in London. The point of this was to create 3D images which could be used for qualitative and quantitative comparisons of the cast and the originals. The casts were made from molds taken over 100 years ago, in some cases near 200 years, before the original sculptures were removed from their place in situ on the Parthenon and into the museum environment. Therefore, part of what I was looking at was to see if the cast contained details now lost from the originals by processes like weathering. The project was made possible by the Broikman Award. As part of this, I received training in 3D scanning at Acon 3D Systems in Germany. I was able to use a 3D scanner on loan, and I was also given access to the computer software necessary to create my 3D images and comparative analyses. This was a really fabulous opportunity for me and meant that I was able to include a really interesting, detailed case study in my thesis that probably otherwise wouldn't have been possible. Of course, as Gabby's just been saying, for good scientific results, we want our data to be repeatable. So we want someone else to, in theory, be able to conduct the same work and achieve the same results. Therefore, we need to be fully transparent about the equipment, methodologies, and software that we've used. Of course, this can be complicated when it comes to processes like 3D imaging that can still be very expensive. Others won't necessarily have access to the same equipment as you. Ideally, though, the basic processes should remain repeatable. The easiest way to try to ensure that your results can be properly tested by others is to use open source software. Of course, advances in technology mean that both equipment and software can become obsolete very quickly, but hopefully you'll have files that can be reused within new generations of software. There is some good open source software now available, particularly for reflectance transformation imaging created by the Cultural Heritage Imaging Group. However, for my 3D scanning, the equipment available to me was a Broikman Smart Scanner, which needed to be used with proprietary OptoCAD software. I used this software to create 3D images of the cast and original sections of the Parthenon frieze in STL or stereolithography files. This is a file format widely used by 3D imaging programs, so although I created the quantitative comparisons of my STLs within the proprietary software OptoCAD, these should be repeatable by others using different software, although it's true that there may be differences in the ways that the scans are then aligned. If I repeated my work now, then, upon reflection, it would probably be good to use proper open source software for more of the analysis. I've used programs like MeshLab, for instance, to conduct some analyses of texture of the 3D images, looking for evidence of things like tool marks. And again, this should be absolutely repeatable. And the move for making more and more things open source will only help with this. Another thing I should point out is that you do need to be careful when selecting file types. So the most common ones aren't always open source. Within 3D imaging, for instance, FBX of Filmbox is a common file format, but it's proprietary and owned by Autodesk. So just to be aware of that. There's also the issue of data storage, which I don't think anyone has really properly resolved. As I've mentioned, as technology advances rapidly, so equipment, software, and file formats can very quickly become obsolete. The first thing, of course, is to deposit your data and make sure it's available for others to work with. Increasingly, journals are allowing you to deposit data along with your published papers. These include, for instance, the journals Digital Applications in Archaeology and Cultural Heritage and the Journal of Archaeological Science, although they aren't necessarily open access unless you pay a fee. In terms of making sure that the files remain available, I really think that the best thing we can do is to use the common non-proprietary file types as far as possible so that even if new software isn't designed to work with them, then it's highly likely that there will be a converter to change them to a type that will work. And the creation of 3D images in projects like mine also raises a few more copyright issues. As I touched upon earlier, the question of who owns the copyright of an ancient object is a knotty one. Certainly museums might claim that they have copyright even when perhaps they don't. In my case, I've completed imaging work with permission of the museums and involving very old objects. The images were created by me. They're not actually photographs, although I did also take photographs, but they're 3D models created from point cloud data. Moreover, in my thesis, I often created composite images, mapping data from an object held by one museum onto an object from a different museum. So I would argue that this is now something new, more akin to a drawing of an object, and that I hold the copyright to that. But I'm not sure on all the details of that. So another point is that my composite images then include data from objects in different countries. So casts of the Parthenon in the UK and sections of the original in Greece. In archaeology and heritage studies, we frequently deal with objects from all over the world. And so far, I think I and most of us have mainly talked from the UK perspective, but copyright laws can be quite different in other countries. So I just want to open up the discussion now really by asking the others what they know about copyright law in maybe Greece or other countries with widely studied cultural heritage material. I know that Egypt, I think, tried to copyright some of its antiquities, certainly for one-to-one reproductions. I'm not sure how that sort of interrelates with how we publish things going forward.
Thank you very much, all of you. This was a really, really interesting session, and I want everyone to hold onto what Emma just asked now. And if anyone want to ask any information about that, I think that would be an interesting starting point. And then if you have any other questions to each other, otherwise I'll just start bombing each of you with them.
I was going to ask that same question actually. That concern. I think it's a lot of us are quite concerned when we saw some years ago both Egypt and Greece making claims to own the copyright on what is clearly public domain heritage objects, and the example that Andrea gave of Italian law where one has to pay a fee to reproduce public domain objects. That's sort of worrying precedent of world copyright use. So I don't have an answer to it except to be concerned, and also wanted to make a disclaimer that for anyone watching this, that none of the four of us are giving legal advice in the process of this, nor will we ever give legal advice on this.
Yeah, that might have been something wise to say. Andrea, if you want to jump in the conversation anytime, remember that you're muted. So you need to unmute yourself.
Perfect. I was like, yes, I understand. Still didn't click unmute. No, I think, yeah, it's interesting because I think it really depends on the jurisdiction, but I think it also is, there's a kind of a collective momentum just, in the user community about, I guess, kind of the deeper questions about whether copyright is even appropriate, even in jurisdictions that maybe a copyright in this content would be appropriate. It's more about, I guess, the democratization of knowledge and the ethos of institutions and the purposes of preserving and making content available for next generations. That seems to kind of fly in the face when a copyright is claimed and access is restricted. So I think there's, it's the legal question about whether or not there is a copyright and what's appropriate. And a lot of times the incentive to generate new revenue, especially when there's so much like the reduction of government support to cultural institutions is just happening everywhere. And the responsibility is on them to be able to make up for that. So copyright is an incentive. But then it's let's figure out actually where there may be, I guess, an area to generate revenue. And there's been a lot of research recently about how, open access generates a lot of indirect revenue that wouldn't be accessible via the formal copyright avenue. So if we look at the Rights Museum or we look at other institutions, they're getting more people through the door. So there's more ticket sales, or there's apps being made online based off of the data that they made available. A lot of times, even with open collections, publishers are happy to use the images, but they still want to pay the copyright fee just to be careful because they're going to be publishing in other places. So it's not like, just getting rid of this opportunity for revenue. It's changing. That value is changing, and the value is not necessarily tied to like a dollar sign anymore. It's tied to kind of the value and wire in society. So.
Yeah, I mean, I think there are, so many important, interesting points that you all raised, that it's really difficult to just focus on one. But I really like this, let's say, this discussion about, I mean, can an institution actually claim copyright on something that is very, very old? We're talking specifically about ancient art. That is, sometimes, like in the case of the British Museum, also acquired in some, ethically, debatable circumstances. So, I mean, can they claim copyright on something that is, the cultural heritage of basically, another nation? And also, when the user, I mean, the visitor, let's say, is the creator, like it was the case of Emma. It's the case of, a lot of people that just go into the museum and take a picture. And as you were showing many times, and I've seen that in in continental Europe more often than the UK. Maybe if you check the website, it says that you are allowed to take pictures for private use. But when you actually go there, you're restricted for taking any sort of picture, even with your smartphone. And the justification that used to be given is that the photographs damage the object, which I think is just, it's plain lying. It's just to prevent you from taking the pictures instead of buying them. And I really like your suggestion that it is, I mean, it's important to support museums, especially those that don't charge the visitors, but considering this more of a service, like, okay, I want to buy a professional image of that artifact that I like very much, instead of taking just an average picture with my phone with a lot of people around. But let's not call that, copyright.
Yeah, and the Victoria and Albert Museum actually founded an entire photography, like an in-house photography department on selling images at cost to the public. And we're so popular that this is, in the 19th century, they weren't able to keep up with demand. So there is, I guess, a history of doing this, and a lot of justification for doing it in this way. But for whatever reason, over time, with the potential to commercialize this, it's ended up today. Now there's a lot of data, especially from Simon Tanner at King's College, who has said done research on the fact that these specific departments about licensing and either making the contracts or pursuing enforcement or this sort of thing, the people that you employ in order to host that department within your walls actually ends up costing more than the licensing fees that are coming in. So the overhead cost of maintaining this whole system is not, worth it, except for maybe a few institutions that have very specific collections that are bringing in good money. So a lot of institutions are operating these departments at a loss.
Yeah. I also wanted really to thank both Gabby and Emma for bringing up how important is documentation and transparency, not just, in scholarly best practice, but also, in the perspective of openness and allowing other people to build on top of what we're doing right now, so that we don't break that chain of asynchronous collaboration, as Gabby called it. Do you have any other questions or comments? No. Okay.
I was going to ask on that exact topic that you just mentioned, Valeria, is the just to say that anybody who is following this semester's series of videos for as part of an academic program or self-study or whatever, whether those are Valeria's students here in London or any of the other Sunoikisis students in the world, or as I say, independent scholars, I would really like the outcome of the last program in this semester, the last session of the semester, to really be an opportunity to think about all of the work that you've done in digital cultural heritage and digital classics up to now, and what are the licensing and the copyright implications of data that you have used in your work, and what will be the licensing and copyright implications of the way in which you publish and redistribute your work. And I think that's, or even if you're not actually publishing and redistributing anything because you're only doing the work for the purpose of exercises, just to sort of thought experiment, if you were doing this as part of a larger project and you were going to publish it, what decisions would you now make about how to publish it, about how to license it, and how to source that data given the copyright issues, some of which have been raised today. I think those are the questions that I'd really like to see people thinking about.
Yes, and this you will see that it's one of the exercises that we suggested for this session. So have a think about what Gabi just said, and if you are in my class, be prepared to discuss that on Tuesday at the next class, and look together at what kind of files we have used, where we have downloaded them, and how ideally we would have liked to publish the new work that we have done about it. Another exercise that you will find is actually about comparing and, in the first place, exploring the website of some cultural institutions and see how complicated, how clear, how hidden can be the copyright information, as Andrea and Emma showed us. So there are some suggestions of possible websites, but Andrea also very kindly made available a survey with, I think, 130 institutions, so you can pick your favorite one, and they are from different countries. So if you want maybe to compare different terms and conditions in different countries, that might also be an interesting exercise. So these are the last exercises for this term, and I want to thank again my speakers for today. They were absolutely awesome, and all the speakers that have contributed to this term from the beginning, and all the people that have been following loyally so far. So thank you, everyone, and I guess see you, don't know, next year maybe. Goodbye.
Thank you.
Thank you.